Who wants to go? Ms. Farkas?
Your Honor, I did have my out of custody client William Davis show up, if we could handle that one.
Okay.
He's here, 2024 CF 614 and 2023 CF 155. Mr. Davis had some car trouble that is here. We've entered a denial at the last date. Since then, I received an updated offer from the state attorney. If we could continue this so that I could speak with Mr. Davis and with the state attorney about the new offer.
Okay. Continue it to next October miscellaneous?
Yes, please, Your Honor.
Okay, we'll continue it until October 17th, 9 a.m.
I'll talk to you next Monday, okay? All right. Thank you, Your Honor.
Stay in touch with your attorney.
We have a meeting next week.
Yes, Judge.
We're good.
Thank you. You ready on couch there, Ms. Paul?
Yes, we could do Mr. Couch as well.
Okay. And then
Your Honor, this is Ronald Couch, 2023 CF 392, 2023 CF 249, and 2023 CF 255. If we could enter a denial in this case, in all three, I apologize, all three VOPs and...
I think there already has been.
Oh, has there? I apologize. We were appointed after the denial. That's my confusion. So if we could continue this to the next miscellaneous date so I can review the offer with Mr. Couch.
Okay, continue it until October 22nd at 9 a.m.
Thank you, Your Honor. Okay, I'll come see you at the jail. That's everyone I have for the morning.
Okay.
Yes.
See you this afternoon.
I'll stick around.
Let's. Mr. Hall? Miss Hall, sorry. So what- I'm not sure I have you on the docket. Do you have a case number?
It was DC.
What is your name?
Danielle Hall.
Daniel Hall?
Danielle.
Danielle. Okay.
Your Honor, I have the case number.
Is she on today's docket?
She's not on my printed docket here, but I see that her case is 9/17, 9 a.m. on Benchmark, on the
Okay.
clerk's site.
Okay.
It is 23 CF 1269.
Okay.
And this
Has
is,
there been an attorney appointed?
No, attorney.
No, Your
This is
Honor.
the first time up?
It's a notice to appear for violation of probation.
Okay.
And Your Honor, the state has an announcement on this case.
Okay.
The state is dismissing the violation of probation. It's been confirmed that all the conditions have been satisfied by probation.
Okay, well, I guess that, no need to do anything else.
Thank you,
You're
sir.
free to go.
Thank you, sir.
Thank you.
So probation terminated or just VOP?
The VOP is dismissed, is
The VOP
probation
is dismissed.
terminated? I mean,
The termination date is soon, so it'll just come up.
so is it being reinstated or what?
The violation is dismissed, so
Just the
term
violation
will
being
just
dismissed?
end in
The rest
October.
is just, remains the same?
Correct.
Is that okay?
Yeah, this is going to be Mr. Joseph Golden before the court in 19 CF 758. I have a plea agreement to be filed. If I can get Mr. Golden signed.
What's the last name?
Golden, Golden. 9/17/24.
Do you have it? It's 20 on the docket.
You got any approach for the,
You may.
I like a score sheet, but it should not be downward departure.
Okay. Thank you. Do you announce the terms of the agreement?
Yes, Your Honor. Mr. Golden will be admitting the violation before the court. It's adjudication of guilt, revoke and terminate probation, 6 months in the county jail with credit for all time served, $100 cost of prosecution, $150 defender fee. Mr. Golden would ask for 24 months to pay those outstanding fees before they're sent to collections.
That is the state's agreement, Your Honor.
Very good. Mr. Golden, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your agreement, and I see those same terms are in the written plea agreement that you've signed. So just want to make sure, have you read the agreement closely and gone over it in detail with your attorney?
Yes, sir.
Had all your legal questions answered?
Yes, sir.
Have you had all of your legal
Yes, sir.
questions
Yes, sir.
answered?
Yes, sir.
Because by entering this will be a final resolution of your case, but you're waiving some valuable legal rights. Just want to make sure you've gone over with your attorney the right to go to a trial, force the state to prove their case. You're waiving all that in order to resolve it today. You just want to make sure you're doing it freely and voluntarily.
Yes, sir.
Okay? Any other questions of your attorney regarding this plea agreement?
Yes, sir.
Okay. Based upon that testimony, the court will accept your plea agreement. There'll be an adjudication of guilt. Court will revoke and terminate probation, so we're finished with the probation on both of these. And you're sentenced 6 months in the county jail, with credit for all time served. I assume that's for both of these?
Yes, Your Honor.
And concurrent? We'll probably need to stick that in there. $100 cost of prosecution, $150 public defender fee, and you'll have 24 months to pay the cost after you get out in order to, so they don't go after your driver's license. Okay.
Is that adds on to my, does that include my old fine? I had $650 fine, so that just adds to that?
Yes.
Yes,
Okay. Okay. Thank you very much.
Okay, thank you, Lord.
Thank you, Greg.
Your Honor, this is going to be Mr. Dayton Grag before the court in 22 CF 1893. We moved him up for an early plea. I may approach with the plea agreement, Your Honor.
You may.
There'll be a modification, so there'll be no not necessary or score sheet.
Okay. Very good. Would you announce the terms of the agreement?
Yes, Your Honor. Mr. Grag will be admitting the violation before the court in 22 CF 1893. Going to maintain the withhold, modify and reinstate the supervision. Probation will be expended by 24 months from the termination date of September 12, 2024. Defendant will be placed on drug offender probation for the balance of the supervision. Required to enter and complete the Keaton, Barsh, the bed, and any aftercare. Curfew on drug offender probation will be from 9 a.m. to 6 a.m., which can be modified by parole and probation for work purposes. $100 cost of prosecution, $150 defender fee, complete original requirements.
That is the state's agreement, Your Honor.
Very good. Is it Grag? Is that how you pronounce it? Mr. Grag, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney state the terms of your plea agreement, and I see those same terms are in the written plea agreement that you've signed. Have you read this closely and gone over it in detail with your attorney?
Yes, Your Honor.
You understand that by entering this, this will be a final resolution of your, of these VOP charges.
Yes, sir.
But to get here, you gotta waive some valuable legal rights, the right to go to trial and force the state to prove their case. You're waiving all that in order to get this final resolution. Is that what you wanna do?
Yes, sir.
And you're entering this freely and voluntarily, nobody threatened or coerced you to get you to enter into this, did
Yes,
they?
Your Honor.
Did anybody threaten or coerce you?
No, sir.
Okay. Based upon that, the court will accept your plea. The court will continue to maintain the withhold of adjudication, which obviously is very important for you. Modify and reinstate probation, and what you're gonna do, we're gonna extend it for 24 months from the termination date of September 12th of 24, which is a couple days ago. Defendant will be placed on, you'll be placed on drug offender probation for the balance of the supervision. And as a condition of the probation, you're required to enter and complete bars to bed, the Keaton program, which is, and any aftercare that comes along with it. Curfew on the drug offender probation will be from 9 p.m. to 6 a.m. You can modify it for work purposes, and then standard costs and public defender fee. And you must complete any other original requirements.
Yes, sir.
Any questions?
No, sir.
Okay, good luck.
And I think the Latin term for that is nunc pro tunc, if I remember correctly.
I've heard that term once or twice.
Judge Stone got me on that a few times where he backdated orders.
Great.
No.
Your Honor, this is going to be Mr. Chad Gray before the court in 24 CF 1988. Again, I moved him up for an early plea, if I can approach with a plea agreement. I don't have a score sheet from the screen, this will not be done with work around.
Okay. Y'all gonna get me a score sheet later?
Yes, Your Honor.
Very good. Would you announce the terms of the plea agreement?
Depends if I can get a hold of Mr. Maddox, what he thinks he is. Okay. So, not today, though. Okay, so you can, okay. And Your Honor, I'm looking in my file, and I actually have a score sheet of the statement, so take a look at it. I can file that. So save some time. Mr. Gray will be pleading no contest as charged. It's adjudication of guilt, 120 days in county jail with credit for all time served, no probation to follow, $615 in court costs, $150 offender fee. Mr. Gray would ask for 24 months from his date of release to pay those outstanding fees before they're sent to collections.
That is the state's agreement, Your Honor.
Thank you. Mr. Gray, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So, Mr. Gray, you heard your attorney state the terms of your plea agreement. I see those same terms are contained in the written plea agreement. Let me make sure you signed it. I assume you have.
Yes, sir.
Which you signed. So my question is, have you read this closely and gone over it in detail with your attorney? Had all your legal questions answered?
Yes, sir.
Because by entering this, you're waiving some valuable legal rights. Just want to make sure you're doing it freely and voluntarily.
Yes, sir.
And you do understand that by entering this, you are waiving the right to go to a trial, et cetera.
Yes, sir.
Okay, have you had all your legal questions answered by your attorney?
Yes.
Okay. Well, based upon that, then the court will accept your plea agreement. There'll be an adjudication of guilt on all charges. The defendant, you'll be sentenced to 120 days in the county jail for each of the two charges, but they'll run concurrent. They'll run at the same time, so it's a total of 120 days. You will get credit for all time served on both charges. $615 in court costs, $150 public defender fee, and you'll have 24 months from the time you get out of jail to pay your fees and costs before it goes to collection. That'll maybe keep you from getting your driver's license tagged. Okay? Any questions?
No, sir.
Okay. And you do have a right to appeal this, but you gotta do it in 30 days. Thank you.
Your Honor, this is going to be Mr. Richard Harrington before the court in 18 CF 1732. We have a plea agreement to file, if I may approach, Your Honor.
You may.
When I looked at the score sheet the state has mentioned, is not going to be without departure from Mr. Harrington, Your Honor.
Okay. Did you announce the terms of the agreement?
Yes, Your Honor. Mr. Harrington's going to plead or admit the violation in 18 CF 1732, adjudication of guilt, revoke and terminate his outstanding probation, sentence to time served, $100 cost of prosecution, $150 offender fee. He'd ask for 24 months from date of release to pay those outstanding fees before they're sent to collections.
State?
That is the state's agreement, Your Honor.
Mr. Harrington, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So, Mr. Harrington, I see that you signed the plea agreement that contains the same agreement that Mr. Gates just announced in open court.
Yes.
Just want to make sure if you read this and you understand all the terms of the agreement, are pretty straightforward. We're revoking and terminating probation so you get through with this.
Yes, sir.
You're doing so freely and voluntarily.
Oh, yes, sir.
You're waiving the right to go to a hearing and contest all this stuff.
Absolutely, yes, sir.
Based upon that, the court will accept your plea. There will be an adjudication of guilt. Court will revoke and terminate probation, and your sentence is technically credit for time served. You got the cost of prosecution and public defender fee. You'll have 24 months after you get out of jail in order to pay those
Yes, sir.
before it goes to collections.
Thank you very much.
Any question?
Where do I pay the money to?
You pay it to the clerk.
Okay, okay. I'll put that in. Yes, sir, thank you.
Okay. Good luck.
Yeah, this is going to be Mr. Gerardo Hernandez Soto. He's on the A docket with 23 CF 1232, 23 CF 1356. He's also on the afternoon docket under 24 CF 1941.
Okay, hold on a second here. Okay.
At this time, Your Honor, we're going to enter denial on the violations of probation, and then we would enter a not guilty plea on 24 CF 1941. He is currently scheduled for October the 16th.
Okay. We'll continue, we'll enter not guilty plea on the new law charge 1941 and a denial on the two violations of probation. We'll run all the cases together and we'll continue them until the 16th of October, 9 a.m.
That sounds good. John, this is going to be Mr. Raymond Hutchins before the court in 24 CF 1132. We had left him in hopes we could get a plea worked out. At this time, I think we'll need to continue his case to the October 16th pretrial conference, and I'll look to schedule depositions.
Very good. We'll continue this matter till the pretrial conference at 10:16 and 9 a.m.
Thank you, Your Honor. Your Honor, this is going to be Mr. Joseph Kinsworthy, who's before the court in 22 CF 779, if I can have a second. Your Honor, at this time, we're going to enter denial on Mr. Kinsworthy's case. He's got a new charge set for October the 17th for arraignment. If we can have this on that same date, we sent a counter offer. My hope is that we can get it resolved by then.
Okay. So we're going to deny it. We'll put it on October 17th according to the way the computer works. So we'll run them together, but it'll show up as being at 9 a.m. on October 17th.
Yes, Your Honor. And if I can get a resolution, I may move him up to the 16th or something like that, or earlier.
That's fine. Okay. Thank you. I got that right.
He can go back.
That time to figure it out. Change the document.
this. Brandy Jones.
This is my client, Your Honor.
Brandy Jones is right behind her.
I can take it.
Your Honor, this is Ms. Jones before the court. If I can approach with a plea agreement.
You may. Thank you. Would you announce the terms of the agreement?
Yes, Your Honor. This one's a little bit longer and it's got some extra stuff on there.
Okay.
Ms. Jones will be made the violation before the court 23 CF 2283. She was previously adjudicated guilty. We're going to modify and reinstate her probation. We're going to extend it by 12 months. She'll be placed on drug offender probation for the balance of supervision with a curfew from 8 p.m. to 7 a.m., which could be modified by a parole and probation for work purposes. She'll be required to enter and complete the Keaton program, that is bars to bed, and any aftercare. Upon the completion of the Keaton program, the defendant required to enter the Joanne Burge Women and Children's Center or a similar program. Waive cost of supervision, $100 cost of prosecution, $150 public defender fee, complete original requirements.
That is the state's agreement, Your Honor.
Where is the women, the birds?
It's in Defeating, Your Honor.
I've heard very good things about that.
Yes, Your Honor. That was actually Ms. Jones's request to have that added on to Keaton. She's going through a child custody case right now, and the hope is that we can go from an adoption recommendation to a reunification. And so the thinking with DCF is that may be sufficient to get that to change.
Okay. Very good. Ms. Jones, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
So, is the state in agreement, I assume?
The state is in agreement, Your Honor.
So, Ms. Jones, you did hear the terms of the plea agreement that your attorney just set forth. I see those same terms are in writing in the plea agreement that you've signed. So my first question is, have you read the plea agreement closely and gone over it in detail with your attorney?
Yes, Your Honor.
Had all your legal questions answered?
Yes, Your Honor.
Importantly, this will be a final resolution of your violation of probation. But in order to do that here today, you're waiving some valuable legal rights, the right to force the state to prove their case beyond whatever the standard. I don't think it's beyond reasonable doubt. But they don't have to prove their case. You're resolving it here today based upon this agreement. You're waiving those rights. Do you understand that?
Yes, Your Honor.
And you have had all your legal questions answered by your attorney?
Yes.
And you're entering this freely and voluntarily?
Yes.
So based upon that, court will acknowledge that the defendant was previously adjudicated guilty. The court will modify and reinstate probation, and we're going to extend it by 12 months. The defendant will be placed on drug offender probation for the balance of the probation. Curfew from 8 p.m. to 7 a.m., and that can be modified for work purposes. As an additional important condition, obviously, you'll be required to enter and complete the Keaton program, bars to bed, and any aftercare. And upon completion of the Keaton program, the defendant will be required to enter the Joanne Burge Women's and Children's Center or a similar program, waive the cost of supervision, $100 cost of prosecution, $150 defender fee, and complete all other original requirements.
Yes, sir.
Okay? Any question?
No, Your Honor.
So do you have a case plan right now?
Yes, Your Honor, I do.
Okay, how old is your child?
She's 2.5.
Okay. Well, if there's any motivation, that should be your motivation. Take one day at a time. You
Yes,
got a strong motivation to do it, but it doesn't mean it's not going to be easy. It's got to start. Nobody's going to do it for you.
Yes,
It's got
Your
to
Honor.
start with you. But at least you've got some good support and you've got a good program, and we can't always say that, unfortunately, but I think that's the case here. You do have some good programs to support.
Thank you so much.
Good luck with it, man.
Thank you. Thank you. Thank you.
Your Honor,
Thank you,
Carson,
Yes, Your Honor, that was all mine for the morning docket. Your Honor, this is Carson R. Allen before the court, 22 CF 2031. Your Honor, the court has entered an order for a competency evaluation. I communicated with Dr. Zeman, and I believe he's going to try to expedite that report, but we need a bit more time. Could we do a October continuance, and hopefully we'll get the evaluation by then? If he determines she's competent, my understanding is she will have a straight jail offer for her consideration, which she may want to take. I didn't think that the probation thought that it would be good to reinstate her, and that's certainly not the recommendation of the state attorney's office. So it'll be in her best interest to see where we are on the competency eval and go from there in probably October, Your Honor.
Very good. So we'll continue this matter until October 22nd at 9 a.m. and we'll kind of see where it plays out at that point, okay?
Thank you.
What month are we in now?
September 17, ma'am.
Okay.
So,
Pivotal month?
we will. Thank you. Thank you, Your Honor. Steve Medina with Anthony D. Allen, 21 CF 282. My understanding, based on the defendant's unwillingness to do a Phoenix House deal against my recommendation, the state's position is 16.8 months DOC, and I know that he doesn't want to take that. He's unhappy with the situation, probably contends that it's my fault somehow, but I think it needs to be continued and set for a VOP evidentiary hearing, because if the parties can't work things out, I can't force an agreement, and that's the next step.
Okay. He has the right to go to a trial. So we're going to continue this matter to a time to be determined, because we got to get together with Miss Eileen to get an afternoon on our miscellaneous docket. How long do you anticipate the hearing to take?
An hour, Your Honor.
Okay. Very good. So if you'll contact my office, we'll have a hearing set. Okay?
May I speak? I sent in 2 motions for ineffective counsel and a bond hearing. I don't know if you have
Your Honor,
gotten
I checked, when I got back from the jail, and he informed me of that yesterday, I checked in Benchmark, and I did not see any motions,
Are
pro
there
se
any?
motions. In any event,
Let's see.
yeah.
I'm not,
I do not see
I'm sorry?
anything. I do not see anything.
Your Honor, with respect to, if
So
there
you
one-
got something in your hand you think was filed?
I made copies of them. I sent them out Sunday night, and I don't know if they.
Oh, it just was sent out
Yes,
Sunday
yes,
night?
sir. They were just sent out.
Okay.
Your Honor, I certainly do not mind if the court wants to look at these things, but I respectfully, as his advocate, one of them seems to be, maybe it's a Nelson hearing, we can go forward with that right now, that's fine. The other one is if it's a bond motion, I'm not at liberty to file a bond motion because he's VFO of special concern and therefore not eligible, therefore I can't file a meritorious bond motion. So if that was one of them.
I don't see how I'm a bond, can't get a bond. I've had one before. I don't understand.
Well,
the
here's the thing.
circumstances.
I can explain that, so
Yes, sir.
I'm sure your attorney has explained it to you, but you
No,
probably
he
don't
hasn't.
believe it,
No, he hasn't.
okay? There are certain categories in things, and one is based on prior record,
Yes, sir. I
okay?
understand.
Certain categories of crimes that identify you. It sounds very bad, I'm just naming the name. It's called a violent felon of special concern. Once that label gets on you, then it restricts your bond thing. So I'm just telling you the way it is, so.
I just
You
don't-
can look it up, you can represent yourself if you want. If you file a Nelson hearing, we'll get that scheduled up, and if you're gonna do a Nelson hearing, why don't we just continue, you say you filed for a Nelson hearing
No, sir,
already?
I filed for ineffective counsel, yes, sir.
Okay. Might not have shown up yet, is that natural, if you just filed it? Did you just mail it?
Yes, sir.
Okay, so it probably hadn't even gotten to the clerk.
And Your Honor, like I said, I'm ready to proceed on that. If we can be-
I need to look at it, exactly what he's alleging, because then I have to ask my question. I don't want to just do it off the cuff.
Yes, Judge.
So we'll come back on our next miscellaneous docket, which is October 17th. And assuming that's been filed, we'll conduct a Nelson hearing, and then depending on where we go, we'll figure out where to go with an evidentiary hearing if that's still on.
And Your Honor, just for the record, I had informed him of the VFO meant that he was not eligible, but I do want to further clarify that I did look it up yesterday after I met with him, because I wanted to go back and make sure I understood that.
Sure.
And it apparently has a second-degree burglary, which is a qualifying offense to not be eligible. And I don't control that, so it wouldn't be a meritorious motion where I'd file it. Thank you.
He has to have a legal basis in order to file it.
You know, that statute site is 948.06.
Okay.
If he wants to take a look at it, I just happen to know it off the top of my head.
Okay. Thank you, Mr. Gates.
And I would ask the state to, just in case he wants to think about it some more, to keep the Phoenix House option open in the event that he wants to do that.
I will.
Thank you. Yes, this is Mr. Barry B. Benvenue. Did I pronounce it right?
Yes, sir.
22 CF 2296. I have some information after I met with him at the jail. I talked to the state attorney's office. May I have just a second?
You may.
Your Honor, we trying to work this case out. It's probably going to be a straight jail, revoke and terminate. If we can continue this to October 17, I believe.
We can. Continue till October 17th, 9 a.m.
Thank you.
Thank you, Your Honor.
Thank you.
Your Honor, Steve Medina with Thomas L. Brundage Jr., 24 CF1, 23 CF 2202, and 24 CF 1032. I received some information this morning from Phoenix House. May I have a moment with him?
You may.
Your we're at a juncture where the state's indicating its position is 11 months, 29 days jail. He doesn't score DOC, where the DOP to be, basically where he to be found to have committed the violation. Rather than set it for a BOP evidentiary, I've got an evaluation pending by a mental health professional. Unfortunately, Keaton said no to his application, and just this morning I learned that Phoenix House yesterday said no. So the state's position is jail, but I'm trying to get our ducks in a row to maybe take a better look at, is there any kind of outpatient option and so forth. So I need a little more time on that. Can we do October 17, Your Honor?
Okay. Why don't we do October 22nd, just so we can
And I just for the record, he does have, my understanding, he is 100% disabled, and I know it's really hard for him in the jail, so I hope you'll be honest with the jail if you need any treatment to deal with the anxiety of incarceration. I know it's really hard for you. Thank you, Your Honor.
Thank you very much. Okay, I think that's that for this morning. We will reconvene for our arraignment at 1:30. I think we can start right on time.